had no results. All results were not returned. That matter represented a percentage of 7.1. Married in some that in the case of the second respondent, and the evidence for that fact can be discerned from the affidavit in support of the answer on 23rd of April by one Henry Makabaiko as the returning officer. That affidavit, my lord, that is going to form part of our evidence. Our affidavits of Kakire, Gasteras, Kamsine Johnson, Rehema, Tamara Simon Peter, Peace Chogaviru Mugare, and Ahepa Fiona. My lord, then what is the complaint of the petition? The complaint of the petition in summary is to say that there was none tallying of the 14-point decision as it stands from his petition, from her petition. There is no any other complaint against the second respondent. And indeed, the petitioner, during cross-examination, this that actually she has no complaint on the 183 polling stations. The reading of Section 8 of the Parliamentary Elections Act requires a petitioner to have a legal grievance, and particularly in the reading of Section 80, 1A, that you must come to court to demonstrate that there was non-compliance with the Act. And the Act mentioned of my lord in the Parliamentary Elections Act. My lord, it is not enough to access this court glossing over all irregularities. It cannot be enough for a petitioner or any other person aggrieved to access this court without a legal grievance. Within the meaning of Section 8. The court has interpreted this section. My lord, I have two authorities. That's fine. One was cited by counsel for the petitioner. I already have a copy evaluated. One is Owepe James versus Electoral Commission and Israel Edi Wagahun. Election petition appeal number 72 of 2021. I would invite you to read the judgment of my drama on page 17. My Lord, I was supposed to another thought of Jim Moisey. My Lord, Jim Moisey is a High Court decision on page 112. Some effect of that decision, of those two decisions, is that there is a greater burden, or the petition carries a huge burden, for which this one I report, that actually the non-compliance relates to the act. With information, my road, I will read what God said, that under section 61, Mathematics 80, 1A, it is very clear that the non-compliant has to be the provision of the Parliament Elections Act relating to the elections. But secondly, the court has to be satisfied by the failure to conduct elections in accordance with the principles laid down those provisions, and the non-compliance with the rest in a substantial manner. The inquiry therefore has to relate to whether there was non-compliance with the provision of the Parliament Elections Act relating to elections. That presupposes that the specific provisions of the Parliament Act have to be set out to determine the non-compliance. If the first part of whether the Parliament Election was not compliant with is not surmounted, then the second requirement of the inquiry is whether the non-compliance affected the rest in a substantial manner. My Lord, the petitioner has set out in his or her petition that specific provision that was not complied with. And when it is our case that indeed the second respondent complied with all the requirements of the Parliament Elections Act and there was non-compliance. There was no any provision cited by the petitioner that the EC did not comply with any of those provisions. My Lord, I will take all those segmented complaints of the petitioner and indicate to you that actually the electoral commission complied with the requirements of the law. The first complaint, my Lord, of the petitioner is to be found in section 72. But your petition alleges that the second respondent never complied with section 72 of the Electoral Commission of the Parliament Elections Act. My Lord, the gist of the petitioner is that the returning officer proceeded to tally the results of the 183 lots first receiving all the envelopes. But that's the gist of the petition. And the only chose to read only 72:1. He did not bring this one and report the contents of 2 and 3. And this is what 2 says. The returning officer may open the envelopes and add up the number of votes cast, even though some of the envelopes have not been received. If the candidate's agent and the police are going to follow the rank of the inspector of police are present. Maybe the value does not shift to the second respondent. Prove that actually the agents of the petitioner were not in the tally center. It is the petitioner to bring cogent evidence to show that the returning officer invoking section 72, her agents were not in the tally center. That is it. Does it mean that the returning officer cannot tally, even though he has not received all the envelopes? No, the law says that actually he can proceed. 72(2). The only requirement that the returning officer needs to prove before he invokes 2 is to ascertain whether all the agents of both candidates and the tally center. Then the question valid to you will be, did the EC comply with this section? Is that still a complaint? No. And mind you, this is not strange. This is not strange. In Amambaba's 2016, I will provide you a copy, but I won't read the relevant extract at page assistant not at page 141. The court was faced a similar scenario. My own, the presidential petition number 1 of 2016. All of us counsel we are practiced. We are counsel in that matter. But this is what court said at 141. On whether the returning officer actually is close to his power. Proceed to tally before receiving all the envelopes. The Supreme Court had to say this. I'll read this, but I will get to the relevant. Furthermore, the petitioner did not adduce evidence to show that the declaration of forms were not filled by the presiding officer after the closing of the polls and counting of the polls. Neither did he adduce any evidence so that when the presiding officer opened the results, envelopes, before they received all the envelopes from their respective district, there was no police officer at the rank of the inspector police, and above all the candidates, all their agents, bearing in mind the constitutional obligation imposed on the executive cabinet within 48 hours. Now, this is what captured the same scenario. That you must go and prove this one I report, that if you have a legal grievance under this section, prove 2 things. You do not have agents in the tally center. That's number 1. Number 2, there was no police officer under that rank. Man, you cannot tie for life. The time limits within which you have to declare a winning candidate. So the petition is not at liberty even to abscond or to make his agents abscond from there. If one is missing, at least have a police officer. My lord, there is no such evidence that the petitioner was going to present to the Tally Center, and therefore this one cannot be a non-compliance. And that brings me to the decision that gave. You could give us some interpretation of this act. My lord, this is the act. My lord, we are faced with the question then which other law did the second respect not comply with for it to sustain such a grievance? Then it brings me to a second bit of the complaint. That actually you're waiting for results. What happens? That there are no results. The procedure in the entire system is like this. And this is the sun. That when it takes place, it closes. The presiding officer fills the DIR forms, and the transmission process proceeds as such. Now, at that point at the Tally Center, the returning officer is receiving results. Now, this is what the law commands the returning officer to do. One, if you have an envelope and it does not have results, that is section 72.3. And I'm not invited to look at it. And this is a scenario that really happened. You are a returning officer, you are waiting for results. The envelopes are coming. If you go to the envelope and you can't find results, it directs you to go to the report book. The law commands the returning officer look at the presiding officer's report book. Maybe if you can't find it in the report book, the law commands you to go to the ballot box itself. My lord, there's a presumption that actually in those two, you will find the results. The second thing the law commanded you to do is to reseal. The only requirement you need is again to have the other police officer at that rank. This is the scenario. Now at that point, if you can't find those as a returning officer, right from section 72, is that the only option left to you as a returning officer is to declare. My lord, the law does not tell the returning officer to run away. And this takes you to what the petitioner's counsel was proposing, that actually what you are declaring are provisional results. No! These are not provisional results. I'm yet to be convinced by the petitioner in the brief set in my grandma's case, Wendy's case, and Jim West, that the returning officer never complied with this section. The only option left is to declare as a returning officer. Another section, my lord, is what you wrote and noted yesterday in the case of dating Zang. Those exceptions. And I invite you to write in this case. Those exceptions that they gave 2, if results can't be found. 3, if they are missing. And by the way, this section does not even impose a duty on the returning officer to inquire. No. It only commands him that now that you have suspected that you have all this, there are possible ways of where you can find the results. The vote book, the ballot box. After that, proceed to declare. And if you do that, you have not, that is not non-compliance. And my lord, we have been guided by the Supreme Court on such a command of the legislation in sit and several. My lord, this is the election petition appeal number 6 of 2009. It is not up to the suitors, the petitioners, to propose a sanction within the law or to amend it within the law. My lord, while the Supreme Court was dealing with Section 50 of the Parliamentary Elections Act, then it was on the other forms. My lord, in that case, that some results were declared on the woman, the day forms of a woman, district woman member of Parliament. And the argument was that this was not a prescribed form. And what has this to say? That we observe the second phase of the Parliamentary Act, which describes the procedure in regard to declaration of these forms, does not prescribe what will be the effect or consequence of its non-compliance. It appears to me, and that is all, that the section is directed in the sense that it directs how election results and paperwork connected here which should be done. Mere non-compliance with the state in the procedure will not affect the results. And the appeal was dismissed. And in my lord, when you retire to write the judgment, you retire a look and address yourself to that decision. When you read section 72, it gives you the procedure. Like available here, it gives the procedure. That even if I agree with them, that actually there was not compliant with that procedure. So long as the intention of the returning officer or an administrative body like electoral commission is achieved, it is not for the petitioner to say that has affected the results. And this is simply what my lord. And it's also admission that my lord, that in a given scenario, the petitioner cannot purport to say that EC did not comply with the provisions of tally and declaration. And actually, and indeed that was what provision does. And the question would be, then what would be the final result? And where do you read the provision results? My lord, the results of an election is to be in the return form. Under section 77 in the Parliamentary Elections Act. Whether that return form was properly filled is annexed to the petitioner's petition. So the process was complete. The tally sheet and the DIA forms of 183 polling stations which translated into 92.7% of the registered voters of Kawai. That result represents 92.7% of total registered voters of Kawai. That now you are first take a decision between 6%, representation of 6% or 7 vis-a-vis 92. The petitioner also had strange proposals and invoked the non-applicable section. But if I take into that matter, then in the circumstance, what did the returning officer, after declaration, as responsible as administrator of elections, what did he do? When you read the affidavit of the returning officer, I think it's paragraph paragraph 11. That the following day, the returning officer reported to police. Under CRB 350/20, CRB 350 Merit, /2025, and CRB 356/2025. Probably that's what an administrator or the returning officer will do for them to investigate. The report was about the violence that was reported to him on the 14 polling stations. And I was thinking that to evaluate. Because like I just admitted, the electoral process is a progressive nature. You're already there. The law does not say go down. You're in the transmission process. You must first complete the tallying process. One would presuppose, maybe like the petition I wanted, that please hold on to the envelopes you have, rush police, investigate. No. The flowing river principle applies. Finish the process, have the winner declared, then report the relevant authorities. And this is what the electoral officer did. My lord, that fact by the petitioner has not been responded to in the rejoinder, has not been denied, secretly put, and as we speak, maybe the investigation is still ongoing. And that's what we can do as an electoral body, that we give the relevant authorities to investigate. That for you to suppose that you stay the entire process, you wait for the envelope under section 72, my lord, that is not tenable, and that is not a command of section 72 in the tallying process. My lord, we take it to the fourth conference of the petitioner. Interruption. You coached that the petitioner coached our complaint on section 76. Interruption, postponement, and counting tally process. My lord, you're faced with a very peculiar situation. What this section presupposes is that actually when the violence erupts, we are given the time to prepare and safeguard the electoral materials. That's what it presupposes. That you hear noise, people are carrying stones, the mob is being organized, then the electoral body very fast secure the electoral materials for you to be able to postpone the counting. And by this is what comes out in the other evidence, supporting evidence. What is not in quotation is that the polling process was peaceful in the 14 polling stations. That measures had been taken by the second respondent, put all electoral materials in the press. Voters turned up in huge numbers to cast their vote. Polling closed at 4. There was no major incident reported by the petitioner. One other person in the electoral process. Money from the evidence of the supervisor and designated officers is that at the point of sorting, all those who have participated in the process, is that in this process of sorting, NAMBI FARIDAH, it is here. NALUKOOLA, it is here. NAMBI is there. After that process of sorting, there is a heap here, there is a heap here. Now, the winner will be suspected. The loser is suspected. And I don't want to be misquoted for me saying that maybe this could have been attributed to any of the parties. That is when the mob came in and smashed, destroyed the key electoral materials. And these are the key electoral materials. And after taking back section 72, because we cannot evaluate section 76 in this total disregard of section 72. What were the key electoral materials? 1, the report book. Where the returning officers were elected in 72. 2, the ballot box. 3, the DRA forms. But that is the process that the 14 points that was interfered with.
All those documents were
Destroyed. It's an act of God, maybe. But that's an act of Satan, because. But none of what man is responsible for this. And man benefited. But not be different if the winning candidate gained a fair advantage. And how do you tell that you have gained a fair advantage? If at that point maybe the rest of other politics had been done, that will be number 1. You say maybe this one gained because he was losing, they be organized. And then of course suggestions for the other parties. None gain. My only person, the petitioner, cannot come to this court to take advantage of this act of Satan to take us back to the polls. I remember this is where I want to read that this court now he has been under Article Section 82, 5, rather 4. That persons who are duty to inquire. What has intended the inquiry could be the evidence, and indeed it is this evidence, that before you take your decision, make a thorough inquiry. That are you going to give us a decision or a precedent that politicians or supporters of politicians, my lord, or politicians, my lord, or supporters of politicians will always organize themselves in a mob to interfere with the process to access this court. It is a precedent that we are going to look for. Moreover, in a situation where none of the parties benefited, my lord, we have got it from supporters that actually all politicians, be it winning, be it losing, are desperate to win. And that's why court, in one of the authorities, submitted in that even when there is evaluating the evidence, is that you have to give it the care, attention on that. But it calls for wisdom from the presiding judge that you do not want to have a judgment that is going to set a precedent that supporters can interfere with the work of the electoral body to fail it to declare or to use it as a vehicle for a by-election. And why by-election I say it calls for wisdom? Much as I'm a lawyer, I've been forced, my lord, to get one of the interesting verses of the Bible. In making a decision, that is 1 Kings chapter 3, verse 3:15. And my lord, this is about the story of King Solomon. We are all familiar about that story. When he was confronted with a child, and the child is Kawembe, and he said, now what do you want? The other person said, kill. I'm not reading the petition, I don't want to discuss it. The judge said, no. My lord, you need that wisdom. Because this death only calls for wisdom. But my lord also bothers you that at cross-examination of the petitioner, she says, I couldn't get 100 in the 14 polling stations. Yes, I could win in some, but I could not get 100. And that's why I was, then what? You don't want to be declared? You don't want anybody to be declared? When is our child? So, under the inquiry, my lord, that is an area that you invoke the first king, Solomon, for your decision. Then, my lord, after taking all those alleged non-compliances, and having convinced you that actually none of the provision was not complied with, and indeed, there is no section of the law that has been appointed, there is no evidence to that effect, this is where there is non-compliance. As for petition, at least not the petition, proposed. That's why they didn't postpone and count. I've already submitted this one because that was impossible. Even if this court directed today conduct election, I don't know what it will be, in the 14th. It is not possible, my lord, and the principle of adult suffering. Even if it was the following day, it is not possible for the electoral body to have even to propose to have elections in the. Why, my lord? Is that the timing of the mob had frustrated or had an effect on the entire constituency. Why, my lord? And this is what I'm submitting. One, that the results of other polling stations are already been announced, and that has an effect of the proposed election, the 14th. So the body itself, the second one would not. And simply, none wants, at times that the majority want to associate themselves with the losing candidate. So the results in other polling stations would have an effect on the 14 polling stations. So that is not even possible. So one, you can't order for or postpone elections or repeat elections because the already declared results from these other polling stations will have the effect on the 14th. And it's simple principle. Because under this election that even one voter can make a difference. And that is not available. So, counsel for the petition and in this proposal for that. What was the rush? No. That even if it is today, you can't have that election in the 14th. My ordinary, after convincing you that was no non-compliance, I would probably have stopped at this. But if you're inclined, my lord, find any loan note. The framers of the law never anticipated that you are going to have an excellent election. And that's why they say the family to be free and fair. Not excellent and exceptional. No, these are gradings. That is number one. Number two, that actually it is not enough to annul. It is not enough to annul. That non-compliance must be substantial. So you have a huge burden as a petitioner. That will test my role. And it appears to the petition is only on the numbers, on the other test. On the quartet. And this is why our point of departure is. I really associate myself with the principles of the law. In as far those authorities are applied to my law. only the part where my lord, and I must approve Mr. Kamle, that when he gave some judgments, he picked those that favored him. The portion of the judgment. But you need to. I refer to one of the judgments, my lord, a change Sarapeni. The Court of Appeal, it was applied by him. And my lord, I'll refer you to page 21. I'll give you my copy as well. What did we consider? My lord, counsel for the petitioner omitted the good way it is to bring this fact or principle known to you. This is the authority that trial judge have compared the aggregate number of registered voters from the 17 polling stations of 8,144 together with the renewing value of the first appearance, and then conclude by washing away the first appearance by winning majority. Now this is what he wants you to do. This approach overlooks the fact that each candidate at this election suffered equally from the decision of the Electoral Commission to exclude the votes from the 17 polling stations from the final tally of the results. My lord, there's one thing. In fact, here, the Electoral Commission has admitted. Here we didn't even omit that there was none to omit. And this brings with all the decisions that were supplied by counsel for the petition. And the only distinguishing factor, my lord, is that in all those decisions, there were results. And at this point, I should distinguish it. There are results. That's number one. Number two is that in all those decisions, my lord, the results had been tampered with in terms of altering them, in terms of returning officer deliberately not including them in the tally to favor the other candidate. But more interesting is that in those, the margin was very slim. I invite your lordship to look at them as well and be able to reduce the fact that indeed they are not happening. My lord, the court, after faulting the trial judge, they went on to say the respondent therefore had to decide the verdict that she should have got the majority votes if the votes from the 15 polling stations are reflected to the account. She had the requisite evidence to prove or disapprove this. She did not abuse it, and thus she failed to discharge this burden. So, my lord, all along, what counsel for the petitioner was to invite you to consider the 16,640 registered voters vis-a-vis the difference, which is 8,000 plus. My lord, this judgment, which is supplied by himself, says no. That is not the formula. That you cannot give here and wash away. Because you owe the petitioner, the respondent, you suffered equally. My lord, this is submission of course. There's a couple of level, but it highlighted a very what he wanted and omitted the part we want you to rely on, my lord. My lord, this court counsel of the petition is applied with a judgment or election petition number 66 of 2021. Electoral Commission appearance versus Mosuku Jacob. I also want to distinguish. I want to distinguish this judgment. One, that it is not applicable in the trial of parliamentary elections. This was the local government case. And if my road, I'm saying it is not applicable. And I'm supplying you this authority that is confined such decisions from being relied on by this one I court trying and implemented to that. And it's very simple, my lord. This decision is
First, explain why you say.
read.
First, explain why.
Yes. Okay, my lord. The dilemma discussed in the case of Maputo Augustus, this election petition number 73 of 2016, versus Western David and the Electoral Commission. It is not a my lord one. It's court of appeal, my lord. One, and this is where we were applying that, because of the different standard under section 80. My lord, the standard under Parliamentary Elections Act and the local government is different. And without labeling, I'm going to read you the extra, the decision of court. Most especially the one of criminal. What in that, my lord, is that court had wanted for court to invoke, I know the equivalent section now, by then to have 172, to apply the provision of Parliamentary Elections Act, to apply local government. Court said no. The standard is of balance of probability, it does not exist in local government, my lord. What you are required to prove is satisfaction of court. In the decision that was submitted to you, the standard was different. Satisfaction of court. My lord, here, as well as submitted by counsel, and he took the different decisions on the balance of probabilities, it is not available in a trial of a local government petition. I submit. My lord, even if you have to follow principles, like your lawyer wants you to do, it will still be distinguishable. In the sense that, my lord, there were results. In Mosoko, there were results. My lord, here there are no results, and it is explaining. In that one, the margin was very minimal. And to be very exact, my lord, was less than 100. So, my lord, you that and the principles are not applicable. My lord, you also surprised with the authority of budget. It's also a submission. You cannot apply. It's in budget. Like I said, there are also results. But interesting in budget. in a tampon station returned 100%, and was doubtful. So as you evaluate it, you'll find out that in budget, there was evidence adduced that actually some people had traveled, some were dead, some came up to say, I never participated. They should have. Therefore, would you get 100% of the polling station? The scenarios are different. By when you're faced with a unique scenario, which cannot be resolved by the principles in those cases. I read council has given that, my lord, we certainly that the second respondent did organize the free and fair election. The declaration of the first respondent was based on the majority vote, and that is to say 92%. That would be unfair for the 7% to influence and to be put my road that the 16,640 and influence 180 registered voters. That my lord has going to submit the petition has failed to discharge his duty. To point this one I report, which act of the parliamentary was not complying with. And those cited that he glossed over, there's no evidence supporting them. My lord, you have to write a report. And finally, you'll be pleased to dismiss this petition. My lord was post and that's a definite that actually his interest is not in this petition itself. That my lord will be our post. Submit my lord. Thank you.
My Lord, good morning. I'm a Lord for the record, Alex Muganda. My Lord, for the first respondent, our submissions in reply will be structured and we shall flow the same way we did for the proceeding. We'll have 5 of us handle the different issues that we handle. However, for the preliminaries, I will briefly make a response to the preliminary objections that were raised by counsel for the petitioner, after which I will take leave and senior counsel Babazi will come on later. basically three appeals that were raised. The first one, counsel for the petitioner is asking courts to strike out number of affidavits sworn in support of the answer to the petition on the ground that they are predated. My lord, I would like to briefly submit that the criminal objection itself is misconceived and not grounded in law. The criminal objection itself is misconceived and not grounded in law. Because Rule 8.1 of the Parliamentary Elections Interim Provisions rules that counsel cited in support of the criminal objection does not talk about predating, nor does it talk about when, nor does it talk about when the various affidavits in support of an answer to the petition should be dated or drafted. My lord, Rule 8.1 referred to above is to the effect that upon being served with the petition, the respondent should within 10 days file his answer to the petition with the accompanying affidavits. And my lord, what the petitioner's counsel is doing is the father of the house leaving the dining table and going into the kitchen, and is complaining that you have put the salt before the onions. My lord, within the 10 days that the respondent has under Rule 8.1, he is expected to gather his evidence in those 10 days. So if you have a number of allegations against several people, whatever day you get them in the 10 days is fine. What the law requires that when you're filing, all of these must accompany. Now, there is no evidence on record, my lord, that any of the affidavits that is complaining about was filed in court before the respondent's answer. What we have on record, my lord, is that the answer, together with all the evidence and affidavits, were filed on the 24th. So, my lord, before the 24th, when the filing of the respondent's answer was done, there was no answer. Neither court nor the petitioner would be able to tell whether there is an answer. We can only talk about an answer under Rule 8.1 when it is filed. And my lord, there is no evidence on record or adduced by the petitioner to show that there were any difference in filing dates of this answer. And it cannot become an answer when it is still in the lawyer's chambers. So what council is looking at is the kitchen affairs. He peeped into the kitchen. But what we are saying is that under Rule 81, you wait for the food at the dining table. And it came to the dining table on the 24th. And my Lord, precisely, there is no issue as far as those affidavits are concerned. And we beg that the court be pleased to overrule the objection. But my Lord, in the alternative, even if we are to say that there was a problem in putting salt before tomatoes or mixing them up, my Lord, one of the authorities that was supplied by the petitioners council under volume 3, my Lord, in the bundle, that is Muhindo. Rema versus Winfred Kiza, my Lord, on page 886. On page 886. My Lord, that's volume 3. My Lord, that case citing the Supreme Court decision of Colonel Kiza Besike and Yoel 7, that is number 1 of 2001, on page 886 of the bundle. The Supreme Court held that the court should take a liberal view of affidavit petitions, considering the tight time schedule under which they have to be compiled, unless the omission is material and going to the root of the substance of the affidavit. My Lord, when a respondent is served with a voluminous petition of over 1,000 pages, with a periphery of allegations against everybody in every corner of the constituency, it is not possible, as counsel would want it to appear, that you collect all these people, they leave all the work they are supposed to do, so on the final day when for you are doing your affidavit is when you should now start getting their evidence. No. And what we have been doing in election petitions, the moment you are served, you get a number of lawyers, and each lawyer handles different people. Respond, respond, respond. What is important is that when you're filing, you must file on the same day. So it's not that whoever prepares evidence, they file it not. And when they are all going, they go in support of the petition. And that's what Muhindo and the Supreme Court is saying, that we should not be very strict on those issues. My Lord, on the other objection, which was addressing the issue of annexures, on the issue of annexure, my Lord Counsel took at length to impeach this particular annexure, and we, on observation of the same, note that this annexure was intending to support evidence on the total number of registered voters in the 14 polling stations vis-a-vis the total number of registered voters in the constituency. And this is a document, as alluded to by the first respondent, had been obtained from the Electoral Commission. However, with the hindsight that the same evidence has been adduced by the petitioner in the tally sheet and in the attached voters' rolls for the 14 polling stations, my Lord, we will concede to this. on that annexure. My Lord, is one, which is the parking list, but its complex, it has not been marked. Annexure A to the affidavit of the first respondent in answer, in support of the answer to the petition. So we can concede to that because that evidence is already on record. But it can be done away with as prayed. My Lord, the third and last appeal that was raised was in respect to the affidavit of NALUKOOLA's Rita. My Lord, it was the submission of counsel for the petitioner that NALUKOOLA's Rita's affidavit did not comply with the requirements under the Commissioner for Oath Act. But our submission briefly in response, my Lord, that counsel for the petitioner's submission is unsustainable because he does not lay a sufficient background. He doesn't lay a sufficient background upon which such a prayer can be made. My Lord, when you look at the affidavit of NALUKOOLA, it fully complies with the requirements of the Oath Act. It was duly commissioned by an authorized officer. My Lord, under cross-examination, the witness before court told the court that she appeared before the Commissioner for Oath. She also told the court that they explained to her the contents of her affidavit. She also told the court that after explaining, she got her copy and read it. She also gave evidence that she swore. And the only question which the counsel for the petitioner put before her is whether there was a book. In cross-examination, whether there was a book, was there a book? And it remained vague as that. My Lord, when you go to Section 5 of the Oath Act, the requirement, the main requirement, and this has been demonstrated in a number of authorities, is that the deponent must physically appear before the Commissioner. And the deponent must understand the nature of oath she's taking and what she's swearing onto. My Lord, all the cases, including John Baptist Kapoza, that were supplied to this Numerical court by counsel for the petitioner, in all those authorities, my Lord, the deponents did not appear before the Commissioner for Oath. Did not appear before the Commissioner for Oath. And my Lord, that is conduct that the Supreme Court was condemning. That is conduct that the Supreme Court was condemning. And my Lord, that is distinguishable. And that is distinguishable on how the oath is taken, the mode of taking the oath is a detail. Under section 5.2 of the Oath Act, it can be by Bible, it can be by Quran, or any other custom or mode acceptable. Because we have people who don't even, they are Christians, but for them when they are swearing, they don't touch the Bible. And that is them. Others will only put their hands up. So it's not about a book. Even a book does not mean a Bible. A book can be a book as a book. And that's the only question which counsel asks. So it is very insufficient to lay a background for a PO, as counsel would want courts to believe. And finally, counsel made an alternative prayer. Counsel made an alternative prayer that if court is to agree, with him and strike out the affidavits, of Namakosa, then even her testimony on oath in court should be expunged, should not stand. My Lord, I would associate with the same if I was the petitioner also. Unfortunately, that's not what the law says. And that's not what courts have held. So one, for the record, we do not agree that there was any non-compliance with the oath or the Commissioner for Oath Act. But even if there was, which isn't true, the Court of Appeal, my Lord, in the case of Mugema Peter versus Mudiobola Bet Nasa, we shall rely on this authority later on other issues. My Lord, that is Election Petition Appeal number 30 of 2011. My Lord, in that authority where I happen to be a party, this time not as a lawyer, but as a witness. How do you deal with viva evidence? The evidence that the witness gives here. In the event that the affidavit is expunged, which cannot be done in the current circumstances for the reasons I've given, you also ignore the evidence that a witness gives under oath, and that this oath the same. Does the first oath that was taken before the commissioner affect this oath when the witness comes to court? My Lord, in that decision before you, I also encourage my brother to read there. My Lord, page 17. Under paragraph 10, my Lord, the court talks about how evidence should be given here under section 58 of the Evidence Act in these election petitions. When the witness comes here and takes oath, they are treated the same way we treat them in civil proceedings. That's why the moment she comes here and takes oath, they are cross-examined on what they saw, what they did, what. My Lord, on 17. Yes. Section 58 of the Evidence Act. Yes, my lord, I'm flowing there because on the following page where I'm going to take you, court comes back. So I wanted to just highlight the background. My lord, when you go to page 18, my lord, in this case, where I happen to be party, the evidence of one of the witnesses, the respondent's witnesses, was struck out because it hadn't complied with the Commissioner for Oath Act. Through cross-examination, it was discovered that the witness did not appear before the Commissioner, and it was the witness's evidence himself, Reverend Indanda, that he hadn't appeared before the Commissioner. And what did the court say? I conclude, I've highlighted that part, my lord, on page 18. On the basis of section 58 of the Evidence Act, and on appreciating the above legal authorities on the point, that evidence given to court on oath viva voce, like what Namakosa did here in court after taking oath, under the supervision and the superintendence of the presiding judge, is proper and valid evidence that the court must consider. And my lord, that closes our response to that primary objection, that both limbs of the objection in respect to Namakosa's affidavit cannot be legally sustained. And the petitioner's counsel did not lay a sufficient background for raising the same. Most obliged. My lord, I'll take leave on that and will request our colleague handling issue 1 to take it.
Issue number 1, my lord. The affidavits of, it was toned down to the affidavit of Ben Tallying. For the record, my name is Eunice. I never was in. My lord, I'm submitting in respect to issue number 1, whether the affidavits of Chamber Nathan, Maumbe George William, and Ben Tallying in support of the first respondent's answer to the petition are legally admissible. Each issue, my lord, has since been whether the affidavits originally was whether the affidavits of Chamber Nathan, Maumbe George William, much of that, my lord. Whether the affidavit of Ben Mukasa in support of the first respondent's answer to the petition is legally admissible. My lord, counsel for the petitioner submitted that the affidavit of Ben Mukasa should be struck off because he procured witnesses, George William Maumbe and Chamber Nathan. He says that the affidavit, that the witness participated in an illegality and should not be allowed to continue participating in the proceedings, my lord. But my lord, there is nothing illegal about the affidavit of Ben Tallying. It fully complies with the Commissioner for Oaths Act. It complies with the Oaths Act, and it was deemed read by court. My lord, also the counsel for the petitioner had an opportunity to cross-examine Ben Tallying, and he conveniently disregarded that opportunity. He did not even make a prayer to cross-examine him among the people that he wanted to cross-examine. but now he wants to turn around and make presumptions and allegations and submissions from the bar about a supposed illegality. My Lord, even when you peruse the affidavit of Ben Mukasa, it is only in paragraphs 10 and 11 where he makes reference to one of the expunged affidavits of George William Maumbe. But even as he's making a reference to that affidavit, he only says that he had an opportunity of perusing, of looking at that affidavit. And that is all he speaks about concerning the expunged affidavit in support of the first respondent's answer. He makes no mention whatsoever of the affidavit of Chamber Nathan. But most importantly, my Lord, which is a well-known fact by now in these proceedings, these two affidavits have since been expunged. So it is our submission, my Lord, that we cannot have a conversation about procuring witnesses, about the action being an illegality when the purported procured witnesses no longer have any evidence on the record. My Lord, what counsel is trying to do is to sort of raise the dead. And I think it's important that he lets the souls of the departed affidavits to rest. My Lord, counsel's submission about an illegality, the decision he has furnished with court, all that is evidence from the bar. There is totally no illegality. Totally. And to expunge Ben Tale's affidavit in support of the first respondent's answer, my Lord, is to deny both the first respondent and even Ben Tale Mukasa a right to be heard. It's against the tenets of a fair hearing, my Lord. The affidavit, Ben Tale Mukasa was accused of several acts of bribery by first the petitioner. These are fortified in the affidavits by the affidavits of Wanjala Solomon, Maumbe George William, Chamber Nathan, and all of them are accusing him of committing different acts of bribery. He should be allowed to defend himself. He should be allowed to respond, my Lord, which he has done and filed an affidavit which is already being read by court. My Lord, our prayer is that if it pleases court, only the two paragraphs, paragraphs 10 and 11, only three paragraphs, my Lord, 10, 11, and 12, with the affidavit of Ben Tale Mukasa be severed. From his affidavit. My Lord, severing portions of paragraphs from an affidavit is not removable. In the case of Kiza Besige versus YKM, the presidential election petition of 2001, cited with approval in Mutembuli Yusuf versus Nagumu Moses Musamba, Page 16, my lord. An extract from the judgment, from the holding of Justice Mulenga, observed that in my view, a court can reject offending parts of an affidavit while accepting the rest of the same as it rejects inadmissible oral evidence. My lord, we pray that only paragraphs 10, 11, and 12 be severed in the affidavit of Ben Kasa. And the rest of the affidavit be useful for this court in evaluation of evidence, my lord. Much obliged.
Okay, so next. Mr. Homer, is there anyone submitted?
I'm going to submit on issue number 2 in relation to the factual argument that we debate and bringing back in the will buttress them with the law, the case, may I do the factual?
Okay. So, Mr. Bowles, let's take a short break.
No problem.
Let's review at 11.
Kote muda dakika 10. Oli live ku Shalom Television Uganda. Kamala kusa ku microphone tunyemu dakika 2. Ahora le gusta usar dentro de un cuadro. Oli live ku Shalom Television Uganda mugamba mutemanya atambula nabo Trisha Keller. Teka di pronounce nze bulungi. Kakoza Isa ogamba otya? Tads ogamba otya? Ibrahim ogamba otya? Lydia ogamba otya? Namwena abagiriko tukyagenda maaso ne kooti ya kanso NALUKOOLA. Oli live ku Shalom Television Uganda, so nyabo ampuliriza. Anyway, Kkooti ya kanso NALUKOOLA ekyagenda mu maaso. Baloya bannambi babadde bawaayo okwewozaako kwabwe nga bannyonnyola kkooti lwaki akalulu kalina okusazibwamu. Kati leero abalooya ba NALUKOOLA be bali mu kuteekayo okwewozaako kwabwe nga bannyonnyola kkooti lwaki akalulu tekalina kukola ki kusazibwamu era lwaki NALUKOOLA yateekeddwa okubeera mu paaliyamenti nga akulembera abantu ba Kawempe North. Njogera bino wagga owuliriza sinze live wano mu kooti ku Trade Towers. Comrade NALUKOOLA we yaloopebwa era omusango gwo guli mu kubeera nga guwulirizibwa. Engineer Magomba ogamba otya? Ntadde kalinki awo wansi musubscribe ku backup channel yaffe. Ntadde kalinki awo wansi musubscribe ku backup channel yaffe. Bagenda tubaka eno nga tusigala tuli safe, nga tusigala tusobola okwefuna. Kako katimbi waggulu awo olaba osinzidde erudda wa kati awata ajja kubaabuuza kkooti bw'eddakiika 9 eddemu. Omulamuzi afulyemu katono tubula like 9 minutes to them. Kakoza Issa ogamba otya? Kakoza Issa ogamba otya? Bannange tukyalemiddwa n'okuweera ebisatu ku backup channel yaffe. Tukyalemiddwa n'okuweera ebisatu. Hussein ogamba otya? Sofia okuva UAE Abu Dhabi ogamba otya? Kitata Ibrak ogamba otya? Mustafa agamba ali live okuva Nakasero. Okay, oli mu Nakasero mu tawuni wano Kyakabe nnyo. Sofia ogamba otya? James ogamba otya? Agamba nti happy seeing you, we have just been hearing your voice live from Lila. Hey James Omek obadde tondabangako. James from Lila is saying that abadde tandabangako and is happy to see me. Yenze waaba benti bwenfaana nkulazeeko mutwe gokka. Musinguzi okuva Namayumba ogamba otya? Ab'Namayumba bagamba batya? Jingo Mark okuva Embalala ogamba otya? Embalala mugamba mutya? Ono ali Korea yani ono Kitata Ibrak agamba nti ali Korea Kyakabe nnyo. Sophie agamba it's my first time to see your face. Bwenti bwenfaanana. Ani omulala gwe sinabongako awo wetuyinda kkooti okuddamu. Junior Neps ogamba otya? Ono agamba Ilameka agamba nti ali Kata Doha Kyakabe nnyo. Comrade Ilameka okuva Kata Doha. Nemukone mukalinki ako musubscribe ku backup channel nga n'omulamuzi waddakomawo. Ono Kalulu agamba nti ali Take. Abatake mugamba mutya? Ono Chosen Destiny from Saudi Arabia Kyakabe nnyo. Comrade Chosen okuva Saudi Arabia. Namukinda ensubiddwa kkooti bigenze bitya? Bikyaliwo tebinaggwa. Tweraliikeko tenaggwa. Hussein agatuli yambala engule. Ono Sophie agamba maliriza okusubscribe nga Kyakabe nnyo. Samuel Namulo agamba nti ali Nairobi Kenya. Samuel Nyamulo Nairobi Kenya kwebali live Kyakabe nnyo. Take bali kiriya ne sound ali kiriya nnyo Kyakabe nnyo. Nakayima Halia ogamba otya? Semanyi mulamuzi agenda gamba tugenda maliriza tugenda manya ku nkomerero ya kooti. Raymond Nick ogamba otya? Ali South Africa Kyakabe nnyo. Ani ono situation from UG live leero kiri kiriya nnyo mu kooti. Ne kooti ya Gudi egenda mu maaso, kooti ya Machete ne Edi Mutwe zonna zigenda mu maaso. Leero wali kooti 3. Daniel Kintu agamba ali Moyo well represented. Abe Moyo mugamba mutya? Kyakabiri aba comrades kuva Moyo. Shadrack Timothy agamba streaming live okuva e Kajansi. I know you are winning this. Snoop on top. Okay, Kyakabiri comrade okuva e Kajansi. That is comrade Shadrack Timothy okuva e Kajansi. Banange mutapinga kona mukalink kentadda waggulu. Osubscribe ku backup channel yaffe. Ati se tuwereyo abantu nga 305. Tuwereyo abantu nga 305. Okitegeera baboy. Tuli 295 ate songereyo abantu nga 305. Juga target yaffe yakufuna abantu. Yakufuna abantu 1000. Subscribers apya 1000 tuyaso okubirako live. Kyakabe nnyo. Yenna ageze na subscribe nga kyakayiko na mukalink waggulu awo ku screen yo bokalaba o subscribe nge. Chris Katongole agama. Chris Katongole agamba big up. Eno kese n'okubeera ng'ewangulwa Bwambale Isaac ali bundi bujjo. Abe bundi bujjo mugamba mutya. Kyakabe nnyo ba comrades okuva e bundi bujjo. Jessica agamba nti ali German. Abe German mugamba mutya. Tubatumiddeko eno oli ku Shalom Television Uganda. Dr. Enzyme nze nkuweereza. Bannange bekikakatako abebusaabala mukole oluguudo lw'ebusaabala banaye naye tufudde. Mukole Busaabala road naye tufa. Ani omulala wano gwesikonyaako? Isaac. Sophia ngamba pin your number please. Aleka kupa ku data. Okay, kanji pinning. Enamba hiyo waggulu ngipinninze. Soko bikole Sophie. Christine ogamba otya? Kalidi Sando ogamba otya? Kevin ogamba otya? Muhammad Waiswa ogamba otya bali kutuweereza kwe tulinnya wano eyiganga. Bana biganga mugamba mutya? Oba neddi twaddeko dde eyiganga awo wadde walujjo twadde naku kiswaddeko eyiganga awo. Wali twabeeredde eyiganga awo naku ssenyenyi nnyo mabega. Zinganga 2-3 mabega awo. Twayiseemu nga tugenda e Bugweri. Andy's Godwin oga good morning members. Ogamba otya Andy's Godwin? Bana ate sinjagala kukoneka erinnya lyo bambi tobeereyo n'osirika. Eno channel yaffe ffenna guno mukutu gwaffe ffenna okitegeera. Nga bwe njogera eryange ndize Dr. Enzyme njagala nange nkutumireko. Okitegeera. Namukenda Scovia. Anige sinabongako wanjala manamba bangeko. Bagoma Ibrahim. Nfunyeko amawulire. Ndabyeko amawulire wano ko sinaga confirminga Lopo alinganga alagidde abasajja b'okufuluma bonna parliament. Alina obutambi bwenfunye buli bubiri. Nfunyeko akatambi ka Lopo ng'agamba abasajja okufuluma parliament. Neza buno balaba nga bafulumye. Akwasanga kikonfirminga. Winix ogamba otya? Owen Mwanguzi ali ku Gazaland L3668 Tulutunda perfume kwe tuli nnyo. Owen Mwanguzi agamba nti wali ku Gazaland edduuka namba L3668 batunda perfume. Okay, kyakabi nnyo comrade agakwe bali nnyo live bagaiza mixer ku dduuka lyamwe erya perfume. Katonda apalitira abaguzi ate mutunde okitegeera. Salongo Bobby aga good morning comrade. 2026 protest vote Rebecca Winston is the next president of Uganda. Ogamba otya Salongo Bobby? Kyakabe nnyo olwambuza Shivani agamba ati Shivani ali bulungi nnyo talina tabu yonna. Gundi agenda kafuna galaga nti Eddie Mutwe nabakuleetebwa mu kooti nakwaddeyo kooti ejjudde abantu bamulindiridde naye tannabakuleetebwa. Okay. Ani gwe sinakubangako. Waliwo naye Sebufu Nicholas ali Lugoba. Okay. Lugoba wene Kawempe oba basalabidde Lugoba Kawempe nasa something like that ebitundu byeyo. Ogamba otya muganda wange Lugoba Sebufu Nicholas. Kiwanuka Robert naffe kwe tulya ne Dubai. Abeewo ab'e Dubai mugamba mutya? So for Nicholas for all parties I'm available. Yes, for all parties anti okulanga ki for all parties oli mukubi wa bifaananyi okola tenti biki amuza okuva Embale City ogamba otya? Kale Kenneth agamba nti thanks comrade. Kyakabi nnyo comrade Kalule kwagala anointed wadde obuze ne Goloba Crash sikyamulaba. Nja kubasoma kolera abapya muteekewo comment section, mugenda mu comment section yawo. Aisha Kyobutungi ogamba otya? Agamba nti ali Masaka. Shivan Achan agamba hi tata, hi mami ogamba otya? Okay. Nowaheleza Lashington ogamba otya? Chaze building tomorrow Uganda. Chaze Edward ogamba otya? Cheka commenting amweddeyo ono ye Abdusalam Kaswa agamba nti I'm Danish Abdusalam Kaswa aka Kaswa Derek from Crescent Islamic Day and Boarding Nursery and Primary School. Agamba nti ali from Crescent Islamic Day and Boarding Nursery and Primary School. Lulisangibwawa kwagala agabe kutuweereza. Sam Rogers agamba NALUKOOLA on top. Just saying myself too happy. Eddakiika kooti zatwadde ziweddeyo saana egenda kuwummula egenda kuddamu.
Agenda mu 10.
Ali ku parliament.
Ali mu 10.
My Lord, for the first respondent, I'm going to handle issue number 2. Issue number 2, we are looking at non-compliance with the electoral laws related to parliamentary elections. We are also looking at how the non-compliance affected the results in a substantial manner. And in looking at that, we need to consider, as my friend Mr. Faride argued on the balance of burden of proof and balance, rather standard of proof. We will not depart so much from for us, our point is, first, was there non-compliance? My Lord, I will invite you to look at the pleading first, the petition itself. And we are looking at paragraphs 7.3 My Lord, the petitioner's first complaint is that the second respondent failed to ensure that polling takes place in a free and secure environment, contrary to section 61. My Lord, if you look at section 61, section 61 says the presiding officer, that is the margin one, shall ensure that polling takes place in a free and secure environment. And the rest of the subsections show what a free and rather secure environment is: appointment of the constable, can I read? 60 says presiding officer shall ensure that polling takes place in a free and secure environment. That is the statement. Then it says the presiding officer, other than a presiding officer for a polling station located in an urban area, may, in the absence of a police officer, appoint at least one person present and resident within the area of the polling station as an election constable to maintain order at the polling station. So you must have an election constable at the polling station to maintain order. At the polling station, throughout polling day, where the presiding officer finds the services of an election constable essential. The presiding officer may only appoint a person other than a police officer to be an election constable when there is actual or threatened disorder, or when it is likely that a larger number of voters will seek to vote at the same time. It goes on and on. My Lord, apart from the affidavits, the 14 affidavits, which I will come to, they just say there was voting. None of them said there was no election, because that is proof whether it was secure or not. And then none of them said that there wasn't polling. My Lord, I will invite you to look at the meaning of the word polling. Polling means casting your vote. Casting your vote. It is not the other. I will also go to that issue, but polling, casting your vote. So, if you look at the evidence on record, if there is any, the secure environment was there in compliance with section 6. If the petitioner had wanted to prove that there was non-compliance with section 6, one would have come up with evidence that there was no election constable. One, there was no polling. That would be put that in the first. There was no election constable. So the environment was not secure. All that is missing, and it is our submission that they have failed to prove non-compliance with section 6. I will not go on repeating myself on that. Then we go to 7.32. failed to count votes cast at the impugned polling stations and record the results in the DR form, contrary to section 66. That's my lord from his own submission. See, the results were none. There was nothing to count. So you cannot be faulted for not counting when there was nothing to count. From his own evidence. What happened has been stated. My learned friend, Mr. Sabiti, attributed it to Satan, but it happened. So without results, you cannot count. So you cannot say there was non-compliance. So that aspect was also not proven, whether even to the standard. Besides proving it to the standard, it did not even discharge anybody. Just came and explained that there was violence. So if he had wanted, would have come up to show what votes were not counted and how they had, unfortunately, they did not have polling agents as it demonstrated by other the polling agent sits on the table, which is assigned, is also part of the law. You record and tick off in the register. X has come, Z has come, and you say at the end of the day, there were about maybe 400 or 600 people who turned up. That evidence was not brought. 2, from their own evidence, there are BVVK machines, which they mentioned. What they do, they are now part of our law. There is a certain instrument making it part of the electronic voter registration. It was available. They could have gotten orders for discovery and used that to show that at least in polling station 1, there were 500 people who turned up. In polling station 2, there were these other people who came up. No such evidence was adduced. And so we cannot say the votes that were not counted. We go to 7.B3, failed to collect and transmit the results of the impugned polling station. Same thing. You cannot collect and transmit non-existent results from their own. Then failed to keep safe custody of the electoral materials. Same thing, my learned friend mentioned the key electoral materials. Failed to adjourn or postpone the counting of votes at the impugned polling station. And tallying of the results, my learned friend also mentioned that Mr. Carole read subsection 1 and did not read subsection 2 and subsection 3. That actually syncs with 7.36 because you read section 76, section 72(1), and section 77. So the sum total of 7.3 is there was no proof at all, and the burden was on the petitioner to show that the second respondent did not do what. Now, my lord, we go to 7.4. 7.4 says the four-stated failure and non-compliance accordingly disenfranchised the voters at the above polling stations. So how many voters disenfranchised would be the question before us. Mr. Carole, I'm sorry, maybe I should use the petitioner instead of saying Mr. Carole. The petitioner wants us to believe that the disenfranchised voters were the registered voters. My lord, section 77 after the counting, the tallying, they mentioned a tally sheet. Tally sheet is where they, after counting from each polling station, then they show which polling station, who got how many at which polling station. How many voters turned up. This tally sheet, my lord, was also availed by the petitioner herself. And I can see it is even certified. I think it complies with all the basics of the law. It is at page 22 to page 30. This tally sheet is a statutory document under section 77. So what it speaks cannot just be contradicted without evidence. What am I saying? The tally sheet says 14 out of, at the 14 polling stations, there were 0. Even for the first respondent, even for other, and the total was 0, 0, 0, 0. Now, if the petitioner wants to change or what we call parole evidence, to say that, well, I could have gotten maybe 400 results at this polling station. So to raise the 0 to a certain number of votes, he has to prove that by evidence. So, my lord, in the declaration, and from the evidence of the petition, there's nowhere where they attempted, except for her own declaration when she was being cross-examined. I think even in the video, she said at the polling station she voted. So the attempt was only for raising one vote out of the 14 polling stations. One vote, that is herself. She was declaring herself as having voted for herself. But the rest of the polling stations, there's nothing. So if you don't have those votes, then you cannot. You have to convert the zero into valid votes in order to say these were missing in for
What about the agents, petitioner agents who said they were voting by saying?
Yes, they said there was voting, but how many people turned? Because it is not enough to say he was voting. Fine. What did you record? It was their burden. What did you record? Alternatively, as I said, what do the BVVK say? You don't just come here and say he was voting. Fine. Even her own affidavit, paragraph 10. Paragraph 10. He says, vote, there was regular voting at that time from 4 p.m. Secure environment for polling. And many voters. So, my Lord, they have thrown to you the word many. How many is many that can affect? Before I even go to affect, how many votes are many to translate into evidence? So there is no evidence of the many. And that burden is huge. We do not discard that burden. Even without going to the standard, there is nothing even probable. There is no probability, just many. Now, when you come from the many votes, the agents themselves, as they will be described them, they were not the petitioner's agents, but NRM agents. Probably that's why they did not take down the money or to record the votes. So as a result, you find the petitioner So, my Lord, from the word go was not evidence provided by the petitioner, save for what we may call assertion or allegation, that in that constituency or in the 14 polling stations, there was 640 voters. She was asked, were they all going to vote for it? I could see she was not really, she was a bit ashamed to answer, but eventually she answered that no. Because in an election, it is not, it is unbelievable for the whole polling station to have all the voters turn out. So the burden was on the polling agents, and the petitioner herself proved that this number, the many number of people turned up. Even if she had not shown that they were going to vote for her, but at least so that is why Mr. Karole was faulting us for engaging in conduct. We're actually trying to assist their case. Maybe if we consider the voter turnout. The voter turnout is not our own invention. It is there on the Tallying. And it is used everywhere. My land friend will show you that the voter turnout is determined because we are looking at mathematics. We are looking at the arithmetic. The result is mathematical. It's a mathematical question. So when we're asking, maybe you would let us change this. He also tried and gave her 12,000. And I think he was coming on our side. Probably if he had maintained, you had a 12,000 and asked for the proof, the evidence. So we're really trying to say, fine, maybe if we use the voter turnout, maybe if we use the sampling from one of the polling stations, but all that failed. Even when she took, she wanted the votes for the polling station where she voted, and I think the councillor Masood, still, because the margin was wide. So this brings me to the margin. My lord, we are looking at the will of the people. Section, rather article now, article 1. Article 1 says, elections held and the will and consent of the people is paramount. Now, they want to bring no evidence and overturn the will of the people. And my land friends will come with the authority. You cannot say that the elections are going to be 100% free of irregularities. The question is how much of the irregularities have affected the will of the people or the result. How much of the irregularities have affected the will of the people in a substantial manner. So in this case, we have 14 polling stations out of 109. From the 183 polling stations, the will of the people, which is 92%, the will of the people was a resounding victory for the first respondent, with a very big margin. And they are saying now, because there are 14 polling stations, we don't know how many people are going to vote. We don't know who would have voted for the petitioner that offset, rather go for a by-election. And it is our submission that that has not happened. Even in just terms of evidence, there was no evidence to prove substantial effect. I saw some cases, of course, here which were being to bring them out. My lord, there is sometimes confusion between substantial compliance and substantial effect. They will draw the line. Our law is substantial effect registers, which the courts have said is a mathematical question. Bring the numbers and bring the win in doubt. Have they done that in their evidence? That NALUKOOLA, rather the first respondent, win is in doubt? That is what should be before you. So, my Lord, when looking at this whole thing, the petitioner had a duty to prove non-compliance, which has not been done, and had the duty to prove that the non-compliance affected the results in a substantial manner. There have been some tests since 2001. There has been an attempt to go for a value judgment. The value judgment is clean election, no people die, no violence. The judges have said no. If these are sporadic, that is why they use percentage. My friend will show you that in the 2016, the people were disenfranchised for about 6.7%. 6.7%. It also happened in 2001. My friend will bring out all that. But I'm trying to show you that the numbers are important because they show the degree of the effect. And the degree of the effect can only be arrived at by adjusting the numbers. If you don't, then you go into a value judgment. So, as a matter of precedent, we have to stick by what the Supreme Court stated, and that is Article 132(4). We are a country of the rule of law, like certainty, like reliability, and when the precedent is set, the courts below follow. There are some judgments that have been given or been decided here, which normally go off. My friend will address you on the effect as being peculiar. There are some judgments that tend to overrule a Supreme Court judgment. We shall also go to that. So, looking at the numbers, we are looking at cogent. That word, cogent evidence that the effect was substantial. Cogent evidence. Well, there are two tests. The victory in doubt. One, the declared winner could not have won. Just not to lose the trail. That is the Doctrine judgments in 201. And uses the two tests. The petitioner had it.
Which case?
Basically versus 7. Doctrine, CJ, the two options. One, whether the declared winner would not have won. So they had a burden to demonstrate using evidence that the declared winner That is the first response. At least I was in this court, there was no such thing. The second test is the votes would have been different in a substantial manner. The votes, not the registered voters. So he concludes by saying, if you use any, then you will be answering the question whether the will of the people was substantial affect. Whether the will of the people goes back to the submissions of my learned friend, the second respondent. You have 7.something% against 92%. Where does the will of the people fall? Mindful of the fact that irregularity will always be there. So, my Lord.
So, the second test, how do you apply it?
Votes would have been different in a substantial manner.
How in this case we got the number?
Because they did not bring evidence. That's why we don't know. But if they had done their job, Electoral Commission is reporting what they did, and that is why they are being faulted. For them, they say 0. Now, the petitioner is saying, no, it should not have been 0. It should have been. So it is their burden. We are having this conversation now because they did not bring evidence. And if we let it go that they did not bring evidence, then we should be the ones to answer. No, we don't have a burden. Because the results were not there. Who says they were not there? Their own evidence shows voting was very okay. From paragraph 10 of the petition, 7 to 4 p.m. The people came. They even have the registers showing other people. Now on that day, the polling agents, why do they go there? They sit, tick, because there is identification. My Lord, do we need that? Because it is part of what the polling agents do, how they do it, the table they sit on, and they are even given the registers. You can know who voted. So without them giving us the voter turnout that day, which becomes now probably the votes. And it also syncs with what my learned friend said. It is a unique case. It is a unique case. In future, agents will do their work. Probably even in this case, they did their work, but they just didn't want to bring the results. Because I cannot imagine. My Lord, Section 51 talks about the polling agents. And they are paid using government money. 51.4. They are paid allowance. So what did they do? apart from telling us that you see, it's so people violate. We should have said, well, the many means 500. The many means 800. The many means this. We are not saying tell us who they were going to vote, but tell us the many. And if we add up, my Lord, it is you to believe or not to believe. No, my Lord would bring it. Yes.
How would that help?
My Lord, that is why we are here. We are here for them to bring, for us to challenge, and then you say, I had this agent. He probably was not. Probably was not paid, so I believe him. There were 14. I don't want to go through their evidence. They all sat there. The only thing they said, voting was okay. BVV, same. They would even mention some points when the BVV came. That is the biometric voter verification kit was not working. Not only that, actually, if they had said that, probably EC would have brought the BVVK. And the only way to do it was for them to seek for discovery. Say, look, because we have done it in most of these. You seek for discovery of the BVV. S becomes now BVV system. So, my Lord, the submission of the first respondent that one, there was no none. Two, even if it was there, we just you might find that you not, because of the violence. I don't know where you get it. It did not affect the result substantially. And why we are saying that, because the authorities say this is a mathematical question, and you are bound by those authorities. That is number one. Number two, my Lord, you are going to set a precedent, and that is what Mr. Kamel wants to do. That is the losing politician. When you see that, oh, I'm about to lose, unleash violence, and at the end of the day, we have no elections in this country. So, your president should be to stop and back those, I don't know what I will call them, and I think satanic who will have those machinations to always overturn, because you would have a by-election. Now, even if now we have another by-election, we must have now sufficient security beyond what is prescribed in the Act to stop the violence. My Lord, maybe just one last. I was not supposed to deal with cases, but I will deal with one case issue. For purposes of Mr. Remy taking on. There's a case of Wakaima Musoken Sereko. It's a court of appeal. It was referred to by petitioner. I know if you look at that, it has also yes. When they were making their lordships, that's an appeal case. In conclusion, based on our findings on the issues above, the appeal substantially fails to make the following orders. So the appellant was nominated wrongly. That is not what we're looking at. There was compliance with the electoral laws when the results of the 24 polling stations were not tallied. Why am I making reference to this? See, the complaint was not tallied in the 24 polling. And if there was no tally, then it affected the results. Now they are saying the non-tally was in compliance with the laws. And that judgment Mr. Cameron, whom I said I would want to present at page 40 of the judgment relied on the statement. We agree with the trial judge that the total number of 17,239 registered voters in all the 24 polling stations whose results were cancelled affected the outcome of the election in a substantial manner. Here they are saying it was okay. Then here they are saying the cancellation affected the results in a substantial manner. I would urge your lordship to note, as you are evaluating and reading some of these judgments, that was 870 volume.
870.
Volume 2. 870 is where they talk about the 874.
874.
Yes. 874 is for the it is their judgment, it is in volume 2. Page, yeah. They have even highlighted.
874.
They are highlighted. It is only 874 which is not highlighted. So, my lord, in making your judgments, you need to scrutinize some of these judgments, such that you may not be misled into making an imperial judgment like this one. So, my lord, let's start ready. We'll take one and regarding the law applicable.
You don't really have enough for the record. But I'm going to highlight some of the judgments used by the petitioner and the purpose really is, my lord, to highlight that there seems to be an attempt by the petitioner to mislead court. And my lord, I will, if I launch into that, as a rider, my lord, I need to highlight very important concept of our practice. And that's the doctrine precedent. Why is it important? My Lord, the point we're making here is, why should you follow certain decisions and why should you not follow certain decisions? That's the point. My Lord, I will start with the decision of the Attorney General versus Uganda Law Society. Constitutional Appeal number 1, 2006. Constitutional Appeal number 1, 2006. And my Lord, in that particular judgment, I am interested in the excerpts on page 13 and 15, my Lord, 15 and I think 16. And my Lord, it is important that I read them because they will operate. They will operate as my backdrop against the arguments I'm going to make. My Lord, page 13, His Lordship Mulenga states, under the doctrine of certeidesis, which is a cardinal rule in our jurisprudence, a court of law is bound to adhere to its previous decisions, save in exceptional circumstances, in exceptional cases where the previous decision is distinguishable or was overruled by a higher court on appeal or was arrived at by curiam without taking into account a law in force or a binding precedent. In the absence of any of the exceptional circumstances, the panel of the appellate court is bound by the previous decisions and other panels of the same court. So my Lord, the point is, if a court is sitting as a court of appeal, and there is a decision that was made 2, 3, 4 years back, that court has no option unless, my Lord, the rider is in that paragraph I have read, the case squarely falls within the circumstances under which they can distinguish, and that judgment which they are not following or they are choosing not to apply is, my Lord, by incuriam. Now, my Lord, that takes me to what is by incuriam. My Lord, it's also considered, if I read every page, you may not think. It is also considered in the same judgment, and the part is highlighted, my Lord, by Justice Mulenga. By incuriam, my Lord, operates in 2 instances. One is if a court sits and determines an issue before it in disregard of an applicable law, then that decision, my Lord, becomes by incuriam, because it is made in the ignorance or in abscondment of an applicable law. That is 1. 2, my Lord, it operates when a court decides a matter before it, and in deciding that matter disregards a binding precedent. Then, my Lord, that decision becomes by incuriam, because it has been made in disregard of an applicable precedent. And then, my Lord, that takes me to the third part of my argument, which is, why do we need precedents? Why do we need precedents, my Lord? My Lord, I will highlight it briefly because it's also covered in the decision of Attorney General versus Uganda Law Society. 1, certainty that if a client walks into my chambers, I am able to advise on the basis of the law of the land. That is what certainty is. My Lord, that also goes together with predictability, my Lord. I should be able to predict that the cause of action which I am bringing before a court to adjudge, I can predict the possible outcome of that cause of action on the basis of the decisions made by the courts. My Lord, that takes me to the other one, which is stability of legal system. Stability of the legal system. My Lord, the matter we are in, the proceedings we are in, I repeat, unique. Why, my Lord? Because these go together with Article 1, which is the will of the people. And my Lord, there must be certainty or stability in our legal system in determining what the will of the people is. My Lord, that would bring me to the last one, which is integrity of the judicial process. My Lord, what do they mean by integrity of the judicial process? That the process should be known to everyone, those actively in participation and those without the legal practice. Now, my Lord, with that rider, the point I'm trying to make here is it has been an argument we have started with all the preliminary objections we were facing. Is we have Supreme Court decisions, we have Court of Appeal decisions, but my Lord, the jurisprudence in election petitions is unstable. Unstable, and that is the problem. My Lord, I have an uphill task of going through this decision of retired Colonel Dr. Chiza Vesje versus YKM7 and another. It is a voluminous decision, but I have no clue. We shall have to go through it, my Lord. And I hope, my Lord, or really my prediction is that I have supplied a copy to the petitioner, that if they save some night tonight and read it, they will tomorrow withdraw the petition. My Lord, that decision settles many of the issues we are facing. Yes. My Lord, I am sorry, I'm trying, it is not numbered. I'm trying to sort it out, highlight the specific parts that I'm interested in, so that I can supply more to this. But I will try to go through. My Lord, this court, this decision has many principles that have been set, and I will go through a few of them and highlight the other principles. My Lord, one of them is what we started with, is the issue of hearsay evidence. But my Lord, perhaps before I launch into that, I also need to highlight to you, my Lord, so that it doesn't get lost on the record. Part of the problem why I brought this voluminous decision is that we have a problem. For instance, the petitioner throughout this trial keeps on cherry picking from this decision, but not what it contains. Why? The decision is of 5 justices. 2 are in the minority and 3 are in the majority. And my Lord, as the doctrine of precedent is, the decision that we go with are the decisions of the majority. But my Lord, you have many Court of Appeal decisions picking the decision of the Justice of Death, picking the decision of Justice Sekobo, perhaps because it is what is appealing to them. But that is not applicable law. My Lord, that's part of the problem that you have. That you have decisions of the Court of Appeal cherry picking from the decisions of both Justice Sekobo and Justice Odeh, but that is not applicable. And my Lord, I will highlight. So my Lord, for purposes of this case, I'm interested in the decisions of the Chief Justice, as he then was, Justice Odoki. I will be highlighting the decision of Justice Karokora, and I will be highlighting the decision of Justice Ulenga, my Lord. My Lord, on the issue of hearsay evidence, it was settled. This is what court was faced with. Court was faced with affidavits that were made on the basis of one belief and hearsay evidence. And my Lord, the presupposition by the council then was that a petitioner or a party to election petition proceedings, my Lord, is permitted to rely on hearsay evidence. My Lord, how does it then become important? My Lord, their lordships, both the 3 of them, all of them, Justice Odoki, my Lord, on page 27 to 29, went at length to determine now, why don't we have to rely on hearsay evidence? And my Lord, I had highlighted it in my submissions on the video. One of the issues he said was, 1, election petitions are sui generis. They are unique.
So if the petitioner,
Yes,
first evidence of other persons, who then also swear that back and forth petitioner, how that in that context,
it's hearsay. The short,
the part of the judgment which says that yes.
my lord, maybe if I go there, I will perhaps, let me give you, my lord, the context. Affidavits, I think, it's not numbered, but I have the numbers from the soft copy. Affidavits, based on information and belief, should be restricted to interlocutory matters. In pleadings which are finally determine the matter, only affidavits based on the deponent's knowledge should be acted upon. My lord, in reaching this decision, they relied on two decisions, a constitutional court decision, Paul Kawanga Semokere and Zakaria Olum versus the Attorney General, and my lord, Charles Mubiru versus the Attorney. And this was the reason, rationale, that in election petitions, unlike interlocutory matters, we are determining the merits of the case. And the proceedings are unique in the nature that the only evidence you can have in court is by affidavit. My lord, they drew an analogy, which I invite you, my lord, when you retire to write a judgment, should be allowed to. Is that if we were proceeding by blind, my lord, would court accept hearsay evidence that is put in the witness statement? Their lordship said no. Then, my lord, that falls on the second leg. The second leg is, what then do you do with affidavits that have hearsay evidence? My lord, that is when the court, all the three justices, said that now you can have the liberal approach. And my lord, the liberal approach does not save the hearsay evidence. The liberal approach is that you sever that part of the affidavit that is hearsay and put it aside. Yes?
I say, I asked you a question. The petition annexed government.
Yes.
Basing on information received from other people, other witnesses.
Yes.
Those other witnesses also come and give supporting affidavit. That's
It is still hearsay.
where the judge
The judgment is at length, but I will be reading excerpts of it and hopefully it will answer. But my lord, I had already read part of it, that affidavit evidence in election petitions and constitutional petitions is restricted to facts within the knowledge of the deponent. So it does not matter that you will bring witnesses after to perhaps say the same things you say. No, the rule is say what you know.
Okay.
Thank you, my lord. My lord, I will not go into it, but it has been highlighted at length. The issue of the liberal approach, affidavits that have issues. Because, my lord, the example I will use, we had an affidavit in Affidavit that was deponed by Rabol, which, my lord, it had been a statutory declaration. It had been deponed in London, not here, and it had not been registered. My lord, by liberal approach, and it will be applicable to the part my colleague is going to handle. Liberal approach would be that please accept that affidavit. Does it fall within what we have restricted? No. Take it in. That is the issue. My lord, now I can go on the other principle. The other principle, my lord, is the principle of agents. My colleague here pointed to the case it should be Muyanja Mbabali. Muyanja Mbabali that lumps up party members and leaders and say that whatever they do, good or bad, is attributable to the candidate. My lord, that was not the case in Chizawesije versus Museveni. Why? My lord, the test, especially in the judgment of Odoki, I had highlighted it is page 168. Just because the decision that was brought, my lord, on the Court of Appeal, that says that there's no test, there's no hard and something rule. My lord, there is. Justice Odok, it says that the test is whether there has been employment or authorization of the agent to do an election work. That is the test. And this is the rationale, my lord. Or perhaps this I should give the background of a proper context. In this election, you had things like NRM task force. You had people like the DISO. You had RDCs. You had people who are operating for the National Security Council. And my lord, all the acts, the petitioner attempted to attribute them to the respondent, who was the President Museveni. Court said no. Why? You must be able to prove that that act for which you are complaining was done, one, with the knowledge of the petitioner. My lord, I commit to highlight that part. Yeah, but I can read part of it, my lord, in the judgment of the law. No, they are not page numbers. That, my lord, that's a challenge I had. But I really wanted the court to have a reading of that. It would be very helpful. On the point I am on, my lord, there was an issue of PPU. But my lord, after this, I will give you this. At least I highlight. My lord, let me read the relevant part. Yes, my lord, it is submitted that the crucial test is whether there has been employment or authorization of the agent to do some election work. In the present case, the respondent appointed his agents and the letters spell out the terms of agents. With respect, I accept the submission of Mr. Vitangiro on this point. The wording of section 6 paragraph C is clear and unambiguous. It requires that the candidate be liable for the actions of his agents only when they are committed with the knowledge, consent, or approval. This is the extent the general principles of the law of agents have been modified. That, my lord, is the relevant part. Justice Odok. Number 168. 168. Yes, ma'am. And my lord, the point I'm making is it disabuses what has been brought to this court, that if, for example, a candidate comes from a party, that whatever each and every member of that party does is attributable to the candidate. It is not the case. That complained act or impugned act must be proved to have been done with the knowledge, consent, or approval. And that will take me to another important example. Well, the other important example is PPU. There has been an issue with PPU in Burundi. PPU, my lord, I think now will be the equivalent of special forces. And this is what Justice Odoki had to say. That, my lord, would be on page, the last part of the resolution of issue number 4. The PPU exceeded their powers by engaging in the intimidation and harassment of petitioners, agents, and supporters. The question then is whether the first respondent is responsible for their action. There was no evidence adduced to prove that the first respondent knew, one, and consented to those actions, or approved them. It may be said that, as the head of state who is guarded by the PPU, he ought to have known what the PPU was doing. That may be a good moral judgment or expectation, but it is not evidence or tact. The first respondent was also a candidate who was busy campaigning throughout the country. There was no evidence that he was responsible for the deployment of the PPU. Therefore, it cannot be assumed that he knew or consented to their actions. The petitioner failed to discharge the burden of proof to their satisfaction of court. My lord, I can go on and on. That's the judgment of Justice Onofi. When we go to the judgment of Justice Karokora, this is what he had to say in respect of proving illegal. No, different point, my lord. On the proof of illegal practices. That illegal practices, this is page 865. At least I have highlighted this part where I can just mark it for you. You can bear it. This issue, it was also canvassed by that Justice Onofi, but this is what he said that, however, it is always important to avoid elevating suspicion and expectation to the status of proof. You know, this is in respect of illegal practices and electoral offenses. The caution that the court is giving to whoever is prosecuting an election petition is that, please, you should have a demarcated boundary between suspicion and speculation, and do not mistake the same as proof. I know that's just but also you must prove that there is connection of the so-called agents to the respondent, and in this case it would be the first. My lord, the same is true for Justice Mulenya. I have highlighted those parts. And when it goes to non-compliance, I am most interested in the decision of Justice Karokora. It's there. And the issue of non-compliance. And my lord, that hints to what my senior colleague was talking about, these tests, and why are they setting the standard. My lord, I will read one of the excerpts to hint to that. In my opinion, there is no way we can avoid considering numbers of voters, of votes a candidate got over the other. The numbers of votes were used in determining the winner of the election. How can we hear the election petition challenging the winner that he unfairly won the election without considering numbers? And for instance, if the first respondent obtained 5,123,360 votes, while the petitioner got 2,559,095 votes, how can we hold that the first respondent was not validly elected without considering numbers of votes which he, the first respondent, obtained over the petition? I can go on and on. But this goes to show you the point that we have been making. Elections are about numbers. The others are really secondary. Elections are about numbers. And there is no way a court would sit to determine who actually won without considering numbers. That's what the decision said. Now, my lord, why are we highlighting this decision? Is that there is a tirade of decisions from High Court, Court of Appeal. All of them seem to be going against the Supreme Court. And my lord, the rider is really Article 132, 34, clause 2, 32, clause 4, on the doctrine precedence. If it is respected, we would not have problems. This petition will not be here. And that's why I'm saying, if it is read, they can withdraw it. Now, my lord, that takes me to where I started. Where I started was, if a court of appeal has made a decision, there is no reason why another court of appeal, different panel, 3, would sit and set aside a decision made. That is wrong, and that decision becomes by jury. And you have many of them in volume 1, 2, 3, 4. That is the decision my senior colleague, Mr. Mbaba, highlighted, the one for Kai. But my lord, I will take you to the decision of Akelo, Acheng Sar Otendi. Should be on. My lord, it is on page 679 of volume 2. Volume 2. My lord, the petitioner highlighted what I think they consider as the relevant part. But I will show you, my lord, that if they had read this decision with the spirit with which we read it, this petition would not be here. Because it is on all four. One, this petition, my lord, the results that were not considered were of 17 polling stations. Yes, my lord. Yes, my lord. Yes. Of no constitutional Supreme Court. But my lord, why we are saying yes, my lord.
I was waiting for you to point them out.
My lord, but
in fact,
in other words, my lord, what I'm
and they wanted you to tell me what are those and where are they, from which decisions are they departed.
yes, my lord, you have Apollo Kantinti, you have Wakaima Musoke. Yes, but my lord, what I'm doing, I'm just giving a sample.
You made that point.
Yes, my lord.
So now you illustration. So that I can make sense of that.
My lord, with your permission, I wish to first sample those two, but perhaps I can highlight them and give it
Which one?
That is Kantinti, Apollo Kantinti. My lord, it had already been cited. So. And then Wafai Mamso, which my colleague really highlighted what the problem was. Now, my lord, let me go to the decision of Acheng Sar. Yes, my lord. My lord, the decision I read, especially the last one of Parapora, said elections are about numbers. About numbers. One. No, before I go there, my lord, now that you have
Okay.
well, what I'm saying, the holding of the Supreme Court, my lord, it is going to be juxtaposed against the holdings of all these other decisions that we think are by incurious. What we are saying, my lord, the point is because, my lord, unless you can allow me and I go the holding, but we will enter into the next day.
Just give it a little.
Yes, my lord, by way of sampling, my lord. What I had said, my lord, I started from the point one, is that the precedent, the doctrine of precedent is cardinal in our jurisprudence. Yes, my lord. My lord, and I started with the Supreme Court decision, and I highlighted issues that were settled that are also in issue in this matter. The issue of hearsay, the issue of proving electoral offences. For continuity, my lord, I am saying the decision of Karokora, I could have gone on and on, my lord, but I have highlighted the important parts, is that elections are about numbers. And this goes on to the decision of Odoki, this goes on to also the decision of Justice Mulema, that elections are about numbers. Now, when you come to an election petition, and the argument is that you cannot use numbers against the argument of disenfranchisement, you are departing from the decision of the Supreme Court. That's not my lord, that's my lord. And with your permission, I can now go to highlight what I am most interested in. Because, my lord, I hope that I would not go because it would be done in assessment of evidence. For example, in Kantinch, I think 9 polling stations were in East, were not tallied, to be exact. And then that was the basis of overturning. In Wakaima, I think a similar scenario, 24 polling stations. And the registered voters were 17,239. But, my lord, when you look at the decision of the Supreme Court, it's saying that, one, look at the margin. The leading candidate, what is the difference between what they have and what the runners-up have? And that margin, those are the two tests, my lord, my senior colleague took you through. And, my lord, I am going to highlight in the another decision, this decision of Achebe. What did court say? And why are we having many other decisions departing from it?
So, Achebe.
Yes, my lord.
Proceed.
My lord, it starts. It is not sufficient that there have been irregularities, but the petitioner must go further and show how they affected the results of the election. That's on page 679. It was left out, I don't know for what. It goes on, my lord. The court should look at the substance of the case and see whether the informalities or errors are of such a nature as to be firmly calculated in a rational mind to produce a substantial effect upon the election. But it goes on that the principle is that elections should not be lightly set aside simply because there have been informalities and errors. My lord, it goes to, when I go to page, I will make the point, my lord, after reading these excerpts. It's really important. On page 681, immediately after the highlighted part, paragraph 1, 2, 3, which the petition highlighted, there's another one. I find, like the trial court did, maybe, my lord, for context, let me read what the petitioner quoted. It was wrong to have added the number of the registered voters in the polling, in the 17 polling stations to any of the candidates because that was speculation as to who voted for whom, and it cannot be said that all of them voted for only the respondent. Hence, the trial judge had, when he added the total number of registered voters in the 17 polling station to the respondent alone. The following paragraph, my lord, says, I find, like the trial judge, the trial court did, that the non-compliance did not affect the results in a substantial manner. I don't know why my colleague left out that, but I can go on, my lord. Yes,
Let's check this. Check. Mr. Wage.
Yes, my lord.
It's not their chain case.
Yes, my lord. My lord, lastly, on paragraph, on page 683, paragraph, I think it's paragraph 3, it says that proof of the above fact, however, was per se not enough for the results of the election to be set aside. Section 61, subsection 1, paragraph A of the Parliamentary Election Act required the respondent to prove on the balance of probability to the satisfaction of court that the disenfranchisement affected the result in a substantial manner. It is significant to appreciate the fact that when the total number of registered voters of 8,844 from the 17 polling stations had been excluded from the total number of the votes cast, the first appellant remained with 41,165 votes, while the respondent had 33,486 votes. This means the exclusion of the results of the 17 polling stations that the first appellant had a winning majority of 7,679 votes from the electorate of Tororo district. The winning majority would not likely grow higher if the results of the 17 polling stations were to be taken into account. It was not a fact that the exclusion of the results from the 17 polling stations affected all the candidates in the election equally, as none of them enjoyed any votes from any said station. So, my lord, the point I'm making is that this decision is of 2011 and 2011, and it was decided in 2012. That's when it was signed. But you have decisions of 2016, 2021 departing from this, and really the rationale and less distinguished, and also provide, the court then must provide what do they find faulty with the logic of the court list. My lord, we don't have it in many of the cases with the court report. But my lord, lastly, what was issue in the case of Kiza Resident, I will find a relevant page and highlight it, was in 206. My lord, I have the decision of 206, I'll highlight the necessary pages as well. The issue was considering what had been categorized as disenfranchised voters of 150 juxtaposed against 10 million. And that's what court was first with. And Justice Katurebe followed the decision of the three justices that elections are about numbers. You cannot run away from that principle in the ballot box and also at the back. My lord, so my lord, with your permission, I can go and highlight the other cases that we are using. Maybe when I finish, my colleague will highlight a mama power, because it's also important. So, my lord, then we would go to the case of Akugiziwe Lawrence versus Muhumuza David. My lord, that decision. Yeah. And my lord, why am I bringing this decision? Because something came in this. What was it? We kept on being asked, I think in the submissions of the petitioner, it was that why were the counsel for the first respondent asking, why do you need another witness to prove this? Why do you need another witness to prove this? My lord, again, why I brought the decision of this arrest, it is also part of this, in determining this issue. And the highlighted part, my lord, is on page 17. Page 17. And my lord, it addresses the issue of partisan witnesses. Issue of partisan witnesses. My Lord, it was also canvassed in Kiza Vestige, the decision of 2006. Why do you need to corroborate evidence of some witnesses? So, my Lord, this is the reason why you need to corroborate evidence of certain witnesses, because this is an election. It is a contest, highly contested. So, any person would first of all want to win at the ballot box. If they have not been able to do that, they would want to overturn the win of the other in court. And my Lord, that's why the decision are saying, right from the Supreme Court, if you have a partisan witness who once says, I was an agent of, say, the petitioner, I saw the agent or the supposed agent of the respondent committing an illegal practice or an offense, and there is no any other person, that evidence, my Lord, must be corroborated. Why? Because such a witness has vested interest in the victory of their one candidate in the election and now party in court. That is, my Lord, the decision of Abugizibu, and it goes on with all the other decisions. My Lord, I think the same issue was canvassed in Salekamba. Yes, Salekamba, my Lord, on proving illegal practices. And my Lord, Gizibwe, also important on why do you need to cross-examine witnesses in election petition. My Lord, you will find that necessary part. So my Lord, the other decisions will be highlighted as my colleagues go on to canvass many of the other issues. Sorry.
My Lord, just to supplement on what my colleague said. I'm Nakwira Musa, L-A-K-U-E-I-R-A, Musa. I represent the first postponement. The petitioners introduced what I could term as a numerical margin test, that to ascertain the substantiated effect of the result, you compare what number of the registered voters that was not included in the tally vis-a-vis the winning margin. In the Sarah Opendi case, Justice Rebecca Sule, in page 21, criticized this approach in his last page. He said, why court should not consider such an approach in evaluating the non-compliance and substantiated effect. This approach, these are its flaws. This approach overlooks the fact that each candidate at this election suffered equally from the decision of the Election Commission to exclude the votes from 17 stations from the final tally. That each candidate suffered equally, is equal at that point. Therefore, the respondent had to discharge the burden. In this case, it's the petition. Had to discharge the burden that she would have got the majority of the votes if the votes from the 17th polling station had been taken into account, which she has not done. She didn't bring proof that any of those 17 polling stations she would have matched the winner. She even said in cross-examination she is assured of winning 2 polling stations where she voted from and where her fellow councillor, who is also an NRM candidate, voted from, that is Senator Masudi Lawrence. The judge said, the trial judge said, the approach what court should use is the one espoused in election petition number, Court of Appeal election petition number 17 of 2022, Edward Yaruhanga Katumba versus the Electoral Commission and NALUKOOLA. That is on page 21 of Justice Reputaso, criticizing the numerical margin effect. Going back to the Chiza-based case that was applied in the Tolit case, also cited by the petitioner, and Shuruk Mukesh Gubai versus Electoral Commission and another. This one was a 2021 election petition of this honorable court, where court emphasized what I'm interested in. Court says to look at the substantiality effect, court has to do an electoral audit. How does it do it? To assess the effect of non-compliance, the court has to evaluate, was quoting Kanokiza BCJ versus ULM7 election petition number 1 of 2001. This is what justice, which was cited with approval by Justice Isaac Muata. To assess the effect of non-compliance, court has to evaluate the whole electoral process and to determine how the result was affected, and then access the degree of that effect. The numbers are useful, so are the conditions that produce these numbers. Using the tally sheets produced by the petition, EC has told that the numbers that in this election were due to a voter turnout of 14.4%. So, to apply their numerical margin test, we have to subject the 14.4% to the 16,640 voters to know, to give us how, maybe who the actual people voted at this 14th polling station. And when you subject that number, as demonstrated by my senior colleague during cross-examination, you will get 2,329 votes. When you compare it with, if we apply their test, the win in NALUKOOLA will still have the winning margin, because 8,881 versus 2,329 votes. Still, she wouldn't have matched the win. Therefore, their non-compliance in case would not have affected the result in a substantial manner. And that is the only logical legal test the substantiality effect can be applied in this case. My Lord, overturning this election, basing on when you subject the 660,000 registered voters vis-a-vis the 999 voters of the whole election, electorate. These voters are just only 8.3%. The polling stations that are saved are only 17.1%. My Lord, this would be a judicial disenfranchisement of the majority, 7.1. My Lord, this would be a judicial disenfranchisement of the majority of the people that voted for NALUKOOLA. And this court has always cautioned itself not to set aside an election given the effect of repeating an election. It imposes unexpected costs on the government, the candidates, and it distorts the operation of the legislature to hold the fresh election. My Lord, with those submissions, our prayer is that you answer My Lord, just to supplement with all what my learned colleagues have said, the annulment will be a nuclear option that one should only trigger when there is clear and convincing substantial evidence, which the petition has not addressed in this court. My Lord, it is our submission that courts must shield the victory of the people and uphold that NALUKOOLA was elected validly and answer this issue in the negative. My senior colleague will now tackle the electoral offenses of bribery, and that is issue 3.
Alex, you got okay, let's do that after lunch at 2:30.
Kale tudingane ku saa 8:30. Saa 8:30.